Did you know there's an estimated $50 trillion worth of natural resources buried right under American soil? That's one of the largest concentrations of mineral wealth anywhere on the planet. But something big is happening right now. Federal agencies are rolling out new land management policies that are fundamentally changing what it means to own property in the United States. Today, we're going to break down exactly what's going on, looking at the policy changes, the legal shifts, and the economic forces that are reshaping property ownership as we know it. Let's start with some incredible statistics. The federal government currently manages 28% of all land in the U.S. That's a massive 640 million acres. If you live out west, that number is even more dramatic. In some western states, the feds manage over 60% of the total land area. In Nevada, it's a staggering 84.9%. And recent policies are introducing new rules that affect even private property. For example, eminent domain proceedings have jumped significantly since 2020, and environmental compliance rules? They now apply to over 75% of private land areas. We're going to dive into how these policies work, the legal tools being used, and what every property owner needs to understand about this new landscape. All of this is documented in court cases, federal registers, and policy papers, and we've done the digging for you. So how does the government actually do this? It primarily operates through three legal frameworks that have been evolving for a while. First, there's eminent domain. This is the government's power to take private property for public use, as long as they provide fair compensation. The game changed in 2005 with the Supreme Court's Kello decision. It expanded public use to include economic development, not just things like roads or schools. This set a powerful precedent. Second is regulatory compliance. This is where environmental or zoning laws can dictate how you're allowed to use your own property. You still own the land, but you have to follow new guidelines. And third, there are civil asset procedures. These were originally for specific legal cases, but are now being applied much more broadly in regulatory matters, always following established legal processes with protections in place. These frameworks are being used in new ways today. A major one is the current administration's 30 by 30 initiative. The goal is to put 30% of all U.S. land and water under federal conservation management by the year 2030. Right now, about 12% of U.S. land has that designation. To hit the 30% target, another 200 million acres need to be added. The administration says this will primarily happen through voluntary conservation easements and partnerships with landowners. Then there's the massive Infrastructure, Investment and Jobs Act. It allocated $1.2 trillion for big projects, and these projects need a lot of land. Think about it. High-speed rail needs about 50 million acres for corridors. Carbon capture technology needs 20 million acres for facilities. And renewable energy infrastructure, like wind and solar farms, requires roughly 75 million acres to meet federal goals. The government estimates that getting all this land coordinated through the open market would cost about $2.8 trillion. So what does this federal land coordination process actually look like in practice? It usually starts with federal agencies identifying land that has strategic value. Maybe it has minerals, water access, great soil for farming, or is perfect for development. Then, they conduct environmental impact assessments to see how current activities might affect conservation goals, like protecting wildlife or water quality. When these regulations change, property values can be affected because owners have to rethink their plans. At that point, government agencies might offer to buy the land at current market assessments through established conservation programs. A great case study is the Dakota Access Pipeline. When some landowners initially said no to easement offers, the feds launched extensive environmental reviews, as the law requires. This long review process created uncertainty in the local property market. In the end, most landowners did agree to easements through a standard negotiation process, and the project moved forward. We're seeing similar patterns across the country. In Texas, agencies have identified 12 million acres of ranchland for potential conservation programs. In Wyoming, new mining regulations are affecting 8 million acres of private land, forcing owners to adapt their plans to meet new environmental standards. Water is another huge piece of this puzzle. The Clean Water Act is the main framework here, and recent updates have expanded federal oversight. The Waters of the United States rule now covers seasonal water features, like streams that are dry for part of the year but fill up when it rains. This rule now applies to an estimated 60% of private land in certain regions. This means landowners need federal permits for many activities, from construction to farming. The permit process can be complex and costly, so many landowners just change their plans to avoid it. The Endangered Species Act works in a similar way. When a new species is listed as endangered, private land and its habitat falls under federal oversight. The recent designation of the monarch butterfly as endangered could affect a massive 165 million acres of farmland along its migration route. Farmers in those areas might need federal permits for things like using certain pesticides or even choosing which crops to plant. The compliance costs can really add up. To encourage cooperation, federal policy includes financial incentive programs. One of the biggest is conservation easements. This is where a landowner can sell their development rights to the government or a conservation group. They get a lump sum of cash and property tax breaks. In return, they agree to permanent restrictions on future development. It's designed as a win-win, preserving natural spaces while giving landowners an economic boost. But there are details to consider. These agreements usually pay landowners about 40 to 60% of the land's development value. Your property taxes go down, but the resale value of the land might also adjust. And if you pass the land on to your kids, they inherit it with those same restrictions. If farming becomes unprofitable down the road, your options for what to do with the land are limited by the easement. And federal investment in these programs is skyrocketing. The budget for these initiatives at the Natural Resources Conservation Service jumped 400% between 2020 and 2025. They plan to acquire easements for 50 million acres by 2030, with state programs targeting another 30 million. Now let's talk about critical minerals. The U.S. currently imports about 80% of its rare earth elements, which are vital for everything from your smartphone to defense technology. Most of these come from other countries, which creates supply chain risks. Here is the kicker. Recent surveys found about $47 trillion worth of these minerals right here in the U.S., but over 60% of them are under privately owned land. Getting permits to mine on private land is a long and expensive process, taking 7 to 10 years and costing hundreds of millions of dollars. So the government is looking at ways to speed things up. Executive Order 14,017 directed federal agencies to find these deposits and develop strategies to access them. And it specifically mentions eminent domain as a tool for minerals considered essential for national security. This isn't new. During World War II, the government used eminent domain to get uranium from private land, compensating owners based on agricultural value, not mineral value. Water rights in the West are another critical area. With ongoing droughts, there's a huge conflict over water. Agriculture uses about 70% of it, but growing cities need more. Federal agencies are using endangered species laws to guide water use, encouraging farmers to sell or transfer their water rights to cities. Take California's Central Valley. To protect endangered fish, federal guidelines encouraged farmers on 500,000 acres to change their practices. Many transferred their historical water rights to cities through structured deals. But the prices were set through federal mediation, not the open market. Farmers got about $1,200 per acre-foot for water rights that could have been worth $5,000 on the open market. There's also the Justice 40 initiative, which directs 40% of federal environmental investments to benefit disadvantaged communities. Under this framing, conserving rural land is positioned as a way to protect urban areas from climate change and pollution. A new financial tool being used is carbon credits. Federal agencies are building a system where landowners can get paid to use their land to store carbon. You could get paid annually starting around $50 per acre and going up to $200 just for maintaining forests or grasslands. For a farmer struggling to make a profit, these payments could be more than they'd make from traditional farming. But these agreements often last for 50 to 100 years and have automatic renewal clauses. So in exchange for annual payments that depend on future government budgets, landowners are signing up for permanent land use restrictions. In effect, the practical management of the land can shift to federal agencies. The scale of this is immense. The USDA says that to meet climate goals, 150 million acres need to be enrolled in these programs. That's an area larger than Texas. Right now, only 12 million acres are enrolled, meaning another 138 million need to join in the next decade. If voluntary programs don't get us there, we could see more regulatory frameworks to encourage participation. Big tech companies like Amazon and Microsoft are also getting in on this, buying high-quality carbon credits from landowners to meet their own sustainability goals. It's clear that the landscape of property ownership in America is undergoing a seismic shift. From conservation goals to infrastructure needs and climate policy, powerful forces are reshaping what it means to own land. Understanding these changes is the first step for every property owner. Thanks so much for watching. If you found this analysis helpful, please give this video a like, subscribe to the channel, and hit that notification bell so you don't miss our next deep dive. See you next time. Hey everyone, thanks for tuning in. Today, we're diving into something huge that is quietly reshaping the American landscape and could affect millions of property owners. It all starts with something that sounds good on the surface: carbon credit programs. Many of these are public-private partnerships. Big companies provide the cash, and federal agencies set the rules for land use and monitoring. But here's the catch. What happens if a landowner can't meet the terms of a long-term contract? Maybe a natural disaster hits, or climate change makes the original agreement impossible. Well, hidden in the fine print of these contracts are asset transfer clauses. If a landowner defaults, ownership of their land can automatically transfer to the corporate partner or a federal agency. No court proceedings, no extra compensation. And it's not a rare occurrence. The USDA reports that default rates on these long-term conservation contracts are around 12%. That's more than 1 in 10. This is all happening under existing federal laws like the Federal Land Transaction Facilitation Act. This law was originally for consolidating federal land, but now it's being used for what's called strategic resource coordination. If an environmental group files a legal challenge, landowners often find it easier to just settle and hand over their property to federal oversight rather than fight a long, expensive court battle. State governments often have limited resources to fight these federal decisions. And when state property rights laws clash with federal environmental regulations, federal law almost always wins. There is even a risk that states supporting landowners could see cuts in federal funding for things like highways and schools. The timeline for all this is moving fast. We've all heard about the 30 by 30 initiative, which aims to put 200 million new acres under conservation by 2030. There are also deadlines to secure critical minerals by 2027 and enroll 150 million acres in carbon programs by 2035. Once land is designated as critical for national security or environmental goals, it becomes incredibly difficult for a private owner to challenge it in court. The economic impact on rural communities is a serious concern. When the federal government takes over land, it comes off the local tax rolls. That means less money for schools, fire departments, and other essential services. We're already seeing young families leave rural areas for better opportunities in cities, and this could make things even tougher. But this isn't a doomsday message. There are things you can and should be doing right now. First, knowledge is power. Understanding how these policies work is the first step. Second, document everything. Keep detailed records of any communication with federal agencies, environmental assessments, and regulatory changes affecting your land. If you need to file a legal challenge, doing it early, before regulations tank your property value, is key. The most effective tool, however, is political organization. When property owners work together, they can influence members of Congress and state officials. Some rural counties are even passing property rights ordinances that force federal agencies to follow local procedures. This creates legal hurdles and public awareness that keeps agencies more accountable. Also, think about alternative land use strategies. Can your land be used for sustainable resource extraction, agritourism, or renewable energy? If you can demonstrate that your private land use serves the public interest while still being economically productive, there will be less pressure to enroll in federal programs. Let us be clear, this isn't about being for or against environmental protection or national security. These are legitimate goals. But the way they're being implemented touches on fundamental constitutional principles about private property. We're talking about an estimated $50 trillion in natural resources under American soil, wealth that belongs to the landowners. So the choice is yours. You can act now to protect your interests through legal documentation, political organization, and smart land use. Or you can watch as federal agencies expand their authority through a complex web of regulations and incentives. The clock is ticking. Thanks for watching. If you found this information valuable, please like, share, and subscribe for more content that matters. Stay informed and stay engaged.